Hi, this is Dan Smith of DPS Legal Counsel, and welcome to today's video and podcast episode of Legal Scrubs, where I discuss issues of interest and importance to health professionals and their healthcare practices. So, today I want to talk about HIPAA, and in particular, two recent developments that just occurred last week. Today is Monday, January the 18th. So this happened late last week, around the 13th through the 15th of January 2021. The first thing I want to talk about with respect to HIPAA and one of the recent developments is a resolution agreement that the Office for Civil Rights, which enforces HIPAA for the federal government, this resolution agreement that OCR, or the Office for Civil Rights, entered into last week with a large health plan in New York State. Essentially, what was alleged by the OCR was that this particular health plan was hacked. And because of the hack, cyber hack, electronic, personally identifiable health information of subscribers and participants in the health plan were made available, taken essentially by the hackers. And this occurred over the course of, it appears, at least on the allegations made by the OCR, from late in 2013, I think December sometime of 2013, until sometime in 2015. So essentially over a year, this information was out there and hacked, and no action allegedly had been taken by the health plan during that period of time to notify the Health and Human Services about the breach. So this particular, OCR and the Health and Human Services basically did an investigation of the health plan and about this breach of with respect to the electronic, personally identifiable health information, and determined that there were some issues dealing with the breach notification and also the security and privacy aspects of HIPAA. They entered into it, like I said, they entered into a corrective action agreement and a resolution agreement with the health plan, and the health plan agreed as part of the corrective action and the resolution agreement with HHS and the OCR to pay a settlement amount of $5.1 million. Now, that is a lot of money, and it points out one thing in particular, that small, independently owned health providers, medical groups, other healthcare organizations that have electronic PHI, it shows that it's how important it is to take action, not only to protect the information of patients, but also to periodically run an analysis, a risk analysis, to see how things are going, and not just do this on a very infrequent basis. It's important to check your how you are securing and keeping private patient information under HIPAA, and also to make sure that you've taken steps to encrypt it and to keep it safe from hackers to the best of your ability. Because as you can see in this case, a large amount of money was paid by this health plan because of the breach and the disclosure of this electronic PHI. Now, that's one thing, and that's the lesson for small healthcare providers, is to make sure that you, on a regular basis, check to see how you are doing to keep your patient information safe, protected, encrypted, and away from the prying eyes of possible hackers. Now, the other thing I want to mention, the other event that happened last week, a recent development with respect to HIPAA and protected health information, was a case that just came out last week, end of last week, from the Fifth Circuit Court of Appeals. This involves a MD Anderson Cancer Center in Houston, Texas. MD Anderson had been investigated for specific breaches of patient information privacy over the course of the past year or so. Essentially what happened in this case was that there was one employee laptop stolen, and it contained electronic PHI that was unencrypted. Then there were two thumb drives that were lost or misplaced, and they also contained unencrypted PHI. These events happened in 2012 and 2013. After an investigation, OCR put a penalty on MD Anderson of over $4.3 million. Now, MD Anderson contested the appropriateness of that penalty by filing an administrative appeal. They lost administratively, but then they filed a court case in the Fifth Circuit, and they won. And this case just came out last week. And what's interesting about this case involving MD Anderson is the court made it clear that because MD Anderson had taken steps to put in place a mechanism for encrypting and keeping safe patient information, it was not an insurer that there would never be a breach or that information could not possibly be lost or misplaced or stolen, but that they had put in place a mechanism. And by putting in place a mechanism, the fact that in these three instances, employees of the medical center had not taken steps to follow the procedure and encrypt the information didn't make MD Anderson itself liable for this large penalty that had been proposed and imposed by the OCR. In other words, the court found that MD Anderson had done what it was supposed to do, put a mechanism in place for encrypting its patient information, and there was just a failure, a small failure, and in the big scheme of things, as big as MD Anderson is, to have one laptop stolen and two thumb drives misplaced that contained patient information when MD Anderson had done all it could to actually require the encryption of its patient information. The Fifth Circuit also went on to discuss the fact that not only had the health provider, in this case, done all it could to encrypt, and that there's no guarantee that information could not be improperly accessed by people who either hack or steal or find information. It made it clear that in this case, the severity of the penalty imposed or proposed by the OCR was way out of line to what had been done in other cases that were similar. So this also makes it clear that if you do have a situation where HHS or OCR comes against you and imposes or proposes a penalty, it's relevant to what they have done with respect to other similar cases, and they can't just single one provider out and impose an extremely severe penalty on that provider when they haven't done the same with respect to other providers in similar cases. There was also discussion of the case that, and HHS had to agree that the penalty itself was beyond its statutory authority. The statutory authority for this type of release of health information was really capped at a much lower level, and they basically agreed after being challenged on it that the greatest amount of potential liability for the hospital was $450,000 as opposed to $4.3 plus million. The other thing is that in addition to focusing on the fact that that MD Anderson had done all it could to put in place a mechanism for encryption, and that the penalty imposed was way out of line from what HHS had done in other cases, and in fact was beyond its statutory authority to impose such a high penalty. The court also talked about what was really a disclosure, an improper disclosure under HIPAA with respect to patient information. In this case, there was no actual proof that anyone outside the hospital had actually been had received a disclosure of this health information, and in fact, it was not. The court made a big analysis on what is a disclosure, and it really required some kind of transfer, either intentionally or unintentionally, by the provider, as opposed to a loss of a laptop or the loss or misplacement of a thumb drive. So if you're a health provider and you have an issue with HIPAA, the main thing is you want to notify HIPAA as soon as possible, because there are requirements that you provide notice under the breach notification rule to HHS when you have a breach. But you also should keep in mind that if you put your mechanisms in place to encrypt and keep secure, you have some good arguments in the event that HHS and OCR decide they want to impose a penalty on you. And in this case, the Fifth Circuit opinion makes it also clear that what they've done in other cases that are similar might be relevant to what they do in your particular case. Now, I'm going to put a copy of this Fifth Circuit case involving MD Anderson on the blog post that I'm putting with respect to this video podcast and video episode and podcast on my website. So if you want to read the case from the Fifth Circuit, it'll be available on my website. All right, I hope that helps today, and we'll talk to you next time. Thanks.